Good morning. My name is Anita Earls, and I serve on the North Carolina Supreme Court. I'm also co-chair of the Governor's Task Force on Racial Equity and Criminal Justice, one of the co-sponsors. I am thrilled to see some of our task force members here, and I hope you'll get a chance to learn from them more about what we're doing. It is such a tremendous joy for me to be able to join the incredible community gathered here, to see so many friends. Thank you for traveling from near and far to give of your time, wisdom, expertise, and passion for justice. And it is my great pleasure to introduce our keynote speaker, retired Judge Nancy Gertner. She intended to be here in person, and unforeseen circumstances has kept her in Boston, but she has been kind enough to join us virtually. To introduce her to you, I want to give you an appreciation of why I hold this woman in such high regard. And I have thought long and hard about what I might be permitted to say to you today. Over the past year, I have faced what at times felt like one of the greatest challenges of my legal career, being accused not once, but twice, of having conducted myself in an unethical manner, contrary to the North Carolina Code of Judicial Conduct. On February 5th of this year, so little less than 2 weeks ago, the United Nations Special Rapporteur on the Independence of Judges and Lawyers issued a statement concerning these events in North Carolina, which said in part, "Combating discrimination must be a priority for all actors in the justice system. To effectively play its role in defending equality for all under the rule of law, the judiciary should be diverse and representative. By raising concerns about representation and bias in the judicial systems, judges can help translate principles of equality before the law into reality." Translate principles into reality. She has a lot of faith in us. The right to make comments like these should be defended and even encouraged. So I believe there is an international support for the efforts we are discussing today, and building and sustaining a local community of those with shared values is key to those efforts. So let me explain myself this way. I am the daughter of a black man who in 1950s Jim Crow America risked his life to marry the white woman he loved. And I was raised in a family that never backed down in the face of racial bigotry and hatred. I cannot turn a blind eye to injustice, and I do not believe that any of you can either. Our keynote speaker exemplifies the courage, tenacity, and brilliance that it takes to maintain the struggle for equal justice throughout a lifetime. She's had at least 3 careers as a preeminent civil rights and criminal defense lawyer, a period she wrote about in her 2011 book, which I recommend, In Defense of Women, Memoirs of an Unrepentant Advocate. She then served as a judge on the U.S. District Court for the District of Massachusetts from 1994 to 2011, writing numerous landmark decisions. And now she is a professor at Harvard Law School and a worldwide lecturer on civil rights, civil liberties, employment law, criminal justice, judicial ethics. She has received too many prestigious awards to count. Some are listed in her bio in the materials. I am grateful to her, not only for one of her many well-trained students, who's now my law clerk, but also for an even more personal reason. This incredibly accomplished lawyer, jurist, and academic became part of the circle of people, including the NC-CRED and the consortium, standing with me last year, giving me advice and support because, yes, she was also the subject of recusal motions and criticism because of her speech. While a sitting judge in 2004, she published a now widely cited law review article entitled "To Speak or Not to Speak: Musings on Judicial Silence." She concludes that essay by saying, "I venerate the law, and especially our system of law, as one of the vastest products of the human mind. But one may criticize even what one reveres. Law is the business to which my life is devoted, and I should show less than devotion if I did not do what in me lies to improve it. I hope you see now why she's a hero of mine. She says she's had an unorthodox career. I would call it a truly inspirational career. Please join me in welcoming Judge Gertner.
Thank you so much. I wish I can be with you. Everyone is hearing me? Is that right?
Yes.
Yes. Yeah, okay. First of all, I want you to know that I'm wearing my signature red, which is all I ever wear. It is, I can't imagine a day in which I wouldn't want to be powerful. So there you go. Could be there with you. There was an illness in my family that kept me from coming, but I really, as I said, I really regret that. I'm delighted to speak here. My husband says that now that I've left the bench, now that I can speak, I can't seem to shut up. And of course, only a husband can say that. If any of you repeat that, it will be another problem. But I'm doing a different kind of speaking as an academic and a commentator than I did as a judge. And I want to focus on the speaking that I did as a judge. I have to admit that Justice Earls' travails were astonishing to me. I was on the bench in the 1990s. When there were commissions on racial and gender equality from one end of the country to the other, when the Council of Chief Justices called for those commissions and called for judges to be attentive to racial and gender bias. And of course, it made perfect sense. In 1935, when the Supreme Court opened its doors in a new building, over the entry to the building was equal justice under law. But of course, this was 1935. And it was a time when racial segregation was embodied in the law, when there was racial violence, when women had not achieved anything remotely like equality. So equal justice under the law was ironic and not a true statement. In one sense, when you ask what role judges and courts should have in extirpating inequality, the answer is we basically set it up. We embodied it. We nurtured it. And so, of course, we have a responsibility to undo it. Is there any doubt that courts have a role in eliminating inequality? I don't think that there is any question about it. Is there any doubt that judges have a role in speaking out? I don't think that there's any doubt. By the 1990s, the efforts to have gender and racial commissions fizzled. Now's the time to take the challenge up again, and I'm really delighted to be here. I have a PowerPoint only because everybody I know in every class has a PowerPoint. I actually hate PowerPoints. This is really likely to be totally inadequate, but I will nevertheless use it. Really, I have a PowerPoint, which is, can everyone see the PowerPoint?
Yes.
Okay. As I said, you cannot speak any longer anywhere in an academic environment without having a PowerPoint. So I wanted to simply give you examples of what the kinds of things that I did on the bench. I don't offer these examples to suggest that everyone needs to do this. I only want to suggest what I did, and what I did both within the confines of the job of a judge writing opinions and outside the confines of the job. So let me begin with a case that was a 1998 case called United States versus Leviner. 1998, I had been on the bench for only 4 years. And I had been a criminal defense lawyer and a civil rights lawyer. And candidly, I was appalled at what I saw. I had never been a public defender. And so the legions of young, mostly Black men who came into my court with what seemed to be minor drug offenses shocked me. But I was a judge, and the U.S. sentencing guidelines were mandatory, and the question was what to do. Leviner was charged with felon in possession of a firearm. Firearm was found in a car that he was in near his feet. It had been fired. It was a serious charge. And he pled guilty, as everyone does in federal court. The sentence would be determined largely by the nature of the crime and by his criminal record. His criminal record score was strangely high. 3 convictions kicked it into a regime that it was very surprising to me. But these 3 convictions were driving with a suspended license. And in each incarnation of these convictions, the sentence was higher, 30 days, then 60 days, then 90 days. In the, forgive me, lunacy, I can now say this, of federal sentencing at the time, his sentence would be substantially increased by these driving offenses because of the amount of time that he had been given. In other words, the guidelines looked not at what was really going on, but look at the amount of time he was getting. I was incredibly troubled by this. His offenses, these offenses for driving after your license was suspended, did not include driving erratically or violating a traffic law. It wasn't driving after your license was suspended, accompanying by, driving too fast or going over the line. It was just driving after your license was suspended. And it was in 3 white suburbs of Boston. The lawyer was a phenomenal lawyer. He was a public defender who argued to me that these traffic violations should not increase his sentence. After all, they had nothing to do with violence. After all, they had nothing to do with guns. If anything, they predicted that he sucked as a driver and nothing more. I saw that, and I surely could have, the language was departed downward, I surely could have discounted these convictions because they had nothing to do with violence, because they had nothing to do with guns. But I saw something else which I needed to say. I wrote a decision. The decision said that federal sentencing, first of all, federal sentencing that is based on state convictions replicates racial disparity in state sentencing. In other words, we exacerbated underlying racial disparities in state sentencing. Because essentially we were counting the amount of time someone got in state court. And if that was based on racial disparities, we were not examining it. And I wanted to examine it. I wrote in my decision that statistics show that African-American motorists are stopped more than any other. I cited to studies about driving while Black. I'm told that this is the first time anyone ever said that out loud. Anyone ever talked about driving while Black in the context of federal sentencing. And I wrote a decision. I love to write. Sadly, it's a problem of mine. Not only do I love to speak, as my husband would say, but I also love to write. And I wrote a decision in part because I wanted to say out loud what I had seen in this case. And I did in the decision you see on the screen. The decision went all over the country. There was a New York Times article, bias cited in reducing the sentence of a Black man. There was TV coverage. There's a wonderful interview with the lawyer involved in which the reporter asked the lawyer, what made you even consider raising race in this situation? He said, I didn't, she did. And of course that was true. I mean, he was almost afraid to say what was apparent to everyone. My decision led the U.S. Sentencing Commission to do a report on the relationship between traffic offenses and lengthy federal sentencing guidelines. I can't say, I didn't change the world, but I needed to say what I saw. And I needed to say what I saw in a way that was understandable to the public I served and the wider legal community. This was in 1998. I was a baby judge, essentially, at that time, but this seemed right to do. Then 4 or 5 years later, I got a death penalty case. Now, in North Carolina, sadly, you are used to capital cases. Not so in Massachusetts. There's no state death penalty. There had not been a federal death penalty until 1994. During my confirmation, I said, and I meant it, that if I had to impose a death sentence, I would. I understood that the Supreme Court had found it constitutional. But just between you and me, I prayed that that wouldn't happen. United States versus Green was again a case in 1998 in which the government sought death. It was murder in aid of racketeering, 4 African-American men, 2 of whom were charged with a capital offense. When I got over my shock that this was brought, that the death penalty was sought in this case, I turned to something very different, which was obvious again to every human being in the courthouse at that time. Everybody saw that when the federal government began to federalize street crime, we began to see overwhelmingly Black defendants, white lawyers, white prosecutors, white judges, white probation officers, and an all-white jury. I couldn't imagine trying a death penalty case with Black defendants and an all-white jury. I couldn't imagine doing it. It was an open secret in the federal courthouse that Boston juries were overwhelmingly white. In part, that's a structural problem. If the case had been tried in the community where the crime took place, Boston itself, 20% of the jury pool would have been African American. But because it was federal, only 7% were African American because the federal court took in Eastern Massachusetts, which included those white suburbs of Boston, and the white population overwhelmed any minority population in the immediate Boston area. 7% of African Americans were in the area from which the federal jury derived. But something else was going on. We were only getting 3%. So we weren't even getting the 7% that was in the larger catchment area of the federal court. We were only getting 3%. Again, these were not issues that even the lawyers raised, but I saw it. Can I do anything about it? I thought. Should I do anything about it? And then what could I do? It was an open secret in the court, and everyone said there's nothing to do about it. It's just demographics. I gave the parties in the case, the defense lawyer, an opportunity to have an expert. The government inquired into this as well. We opened up the question of how did it happen? 3% in the actual jury pool. I might add, we weren't even getting Boston people. We were not even getting white working class people from the Boston area. The juries were overwhelmingly white and suburban. And I found out, of course, something that I should have known to begin with. It was not like there was some clerk that was putting his finger on the scale and excluding Black faces from the jury. It was much more troubling, if that's possible. What had happened was that the white communities surrounding Boston were well funded and they could keep their jury lists up to date. The poorer communities in Boston could not. And so their lists were essentially illusions. Their lists were essentially inaccurate from beginning to end. Summonses would be sent out and returned undeliverable, and they say, well, we did everything we could. So I fashioned an idea. I fashioned a suggestion. My phone is going crazy here, but that always happens. I fashioned what seemed to me a really minor issue, a minor suggestion. And what was it? If a summons was sent to a house in Boston or anywhere else, and it came back undeliverable, then the jury clerk would send another summons to that address, or to that zip code, rather. So let me recite that again. So if it came back undeliverable, you could send another summons to that zip code. Just try again. I required that the list be kept up to date, whatever that meant. And as I said, it was a minor fix to a very, very troubling problem. Another summons to the same zip code. And I wrote, again, because I love to write, I think it was this time it was like a 105-page decision. I'm not suggesting every judge do that, but as I said, just as I never met a microphone I didn't like, I've never met a computer that I didn't like. That was what I did. Again, it went all over the country. It was seen as a sensible solution. It was endorsed by the ABA, and then I was reversed. I was reversed by the First Circuit. The court said there was a cause for concern, but that a change like this can't be implemented by any one judge. I couldn't, in short, be fair in my own courtroom. And if they agreed that I was fair in what I did, of course, other judges would have followed. Rather, it had to be implemented by the court as a whole. Now, that didn't help the individuals in front of me who were facing the death penalty. But in fact, the rest of the court did follow. There was a change to this effect. Keeping these lists up to date seemed de minimis, and sending multiple summonses if they came back undeliverable. The District of Massachusetts followed, as did other courts. And again, because it was a written decision, because I laid out my reasoning, it was followed elsewhere. Another, U.S. v. Wilkerson, was a young man who was going to wind up getting a 10-year mandatory minimum, for based on prior crimes that began when he was 14. When I looked at the prior crimes, he had begun dealing drugs for school supplies. His mother was an addict. His father was in prison. He was on the streets. And once again, I did an analysis of the reason why he wound up in that situation. And it had to do with both the nature of policing in this particular community. It had to do with the fact that he was largely homeless, and it made no sense. I had to impose a mandatory minimum, but I did so screaming. I describe here, in addition, the voir dire that I did in that case, which he remembers to this day. I have interviewed him since I've left the bench. And he remembers that the first juror that we swore in to be questioned looked at him and said, quote, "I am afraid to come into Boston," end quote. And I excused her. I don't want to take up too much of your time. I've written about federal court as where civil rights cases go to die in an article called Losers' Rules. I saw something very troubling, which is that when in a civil case, when you want to grant summary judgment to the government, to the defendant, let's say, you had to write a decision. But if you were denying summary judgment, the case went on to trial. You didn't write a decision. So it occurred to me that the law was evolving in terms of the losing cases, in terms of the defendant's victories. And the precedents were all in that direction. And so over time, the law becomes asymmetrical. I know that I'm going to run out of time here, and so I just want to tell you about my latest projects. Again, I've never met a computer I didn't like or a microphone. I'm writing a book called Incomplete Sentences, and it's about the men I sentenced, some of whom I've just talked about. And I have been interviewing them. I wanted to write about the difference between what I saw as a judge, what I have studied since then about who they were, and then shockingly, what it has felt like to actually meet them. This book has taken me 6 years to write. I think I see the end in sight. But it is essentially an essay about accountability, which is what this conference is about. It's not just whether or not I followed the law in those cases. I did, I had to. But it's about what was my role in the larger system of inequality of which I was a part. And I want to say that out loud as at this moment in my career, when, as I like to say, my chances on the Supreme Court were long ago shot. Finally, finally. I just want to end with this comment in an article that was written about all of the gender and race commissions. Myra Selby says, we must decide whether we will leave a legacy of indifference or opportunity. Remaining indifferent to the problems of race is the comfortable path. And I would add, remaining indifferent makes us look neutral. That's what neutrality, after all, we're just being neutral. That's the comfortable path. Yet walking the comfortable path will trample on individual rights. Now is the time to embark on the hard work of creating a criminal legal system that promotes the goal of equality. So, on the question, should judges speak in their opinions, in their rules, by their example? I say categorically, absolutely, unquestionably, yes. Thank you very much. I'll take questions now.
Judge Gertner, that was an absolutely stunning presentation that we only wish could have gone a bit longer. And speaking
You don't want to invite me to go longer.
And we certainly hope that, I'm saying this to my president of the National Consortium, that in the future that we might be able to invite you to one of our conferences to speak, because this would be an excellent presentation for all of us to hear. Are there any questions from the audience? Anyone? Yes, Mr. Williams. Make it a short question.
This is sort of a memory check, Judge Gertner. I recall, I think the first time that I encountered, I don't know that we met, you was at a CLE that I think it was the National Association of Criminal Defense Lawyers did. You had just become a federal district court judge. And I recall I was so moved by this judge, a federal judge at that, coming to speak to us and giving tips about how we can do a better job of developing a record so that you could do a better job being a judge. Do you recall that, or am I misimagining that?
No, I do remember that. I do remember that. I'm talking about, so I talked to some degree about my opinions, talking then about what our obligation is to speak outside the courtroom. In one sense, I had it easy. And why did I have it easy? I was a judge when the federal sentencing system literally went off the rails. And in one sense, it was easy to know what not to do. What not to do was what we were supposed to be doing. And I wanted to say that in every corner that I could. In fact, I was so troubled by Justice Earls' travails because I spoke out against mandatory minimums. I gave interviews to the New York Times and others. I joined forces with conservative judges who also opposed mandatory minimum sentencing. And all of this was part of what I thought was our obligation to talk about the administration of justice. So I did that throughout my career. As I said, to some degree, it's because I love to talk. This is a serious problem. Ask my kids. When I was asked to participate in this conference, I said, you want a 30-minute, 20-minute, or you want a Fidel Castro 3-hour? And I could do any of that. But are there any other questions? Thank you for the question.
Well, we certainly thank you for your time and thinking it not robbery to be with us today. With that, we're going to end this